This right not to betray yourself goes back a long, long way.
Historically, the privilege against self-incrimination started at the Star Chamber with John Lilburne.
John Lilburne stood up to the Star Chamber in 1637. The Star Chamber was an English court that met in secret and sentenced religious opponents of the king to torture.
What happened in the Star Chamber was that they would call in people and ask them questions. Did you commit this crime? Well, you had no good choices.
If you said yes, they'd torture you. If you said no, they'd say you were lying and torture you. If you refused to answer, they tortured you until you said yes or no. John Lilburne refused to incriminate himself, and what became a rallying cry in England became a fundamental right in the U.S. Constitution.
The framers were very aware that the criminal justice system could be the source of all sorts of abuse. It's a setting in which the government is authorized to really take complete control over an individual's life. And giving the government that kind of authority is both necessary to have an ordered, civilized society, but extremely dangerous. And so the idea is to figure out, how do you create a system that gives the government the power it needs to have to punish wrongdoers without giving the government the power to be abusive.
So the Bill of Rights is loaded with protections throughout the 4th, 5th, 6th, and 8th Amendments that limit what our government can do to people as they go through the criminal justice system. Rules or due process about things like search and seizure, juries to give citizens, not the government, the last word before we take away someone's liberty, a right to a lawyer, no cruel and unusual punishment.
The fundamental principle of our criminal justice system is that you are innocent until you are proven guilty. So the burden of proving an individual guilty of a crime rests with the government.
We have an adversarial system of justice, two sides, prosecutor and the defense. The prosecution, the government, has to make its case, and the defense can put up a good fight or do absolutely nothing. The entire burden to prove guilt beyond a reasonable doubt is on the government.
Because the defendant is presumed innocent and is not required to do anything, actually, in a criminal trial. So they don't have to argue to the jury, they don't have to call witnesses, they don't even have to cross-examine the government witnesses, and the defendant certainly doesn't have to testify.
Because you have a privilege against self-incrimination, that means that you have the right to remain silent.
And a confession is the farthest thing from silence, but here's where it gets really tricky. Ernesto Miranda, like most people, confessed while he was in an interrogation room. And at the time Miranda confessed, it wasn't clear what rights a suspect had in the interrogation room, which had a reputation for being a pretty scary place.
There is a sad history in the United States of not just lights being shown in defendants' eyes, not just long questioning of the sort that really can make you feel under pressure, but of actual violence.
The police developed the third degree, an abusive form of interrogation where they would do some pretty awful things to people to try to get them to confess, beat them, sometimes mercilessly.